Companies Act, Section 110, Postal Ballot. Section 110 of the Companies Act governs the use of postal ballots for conducting business within a company. This section outlines the types of resolutions and matters that may be decided through postal ballots, and the conditions under which they can be used. The section also provides for the recognition of resolutions passed by postal ballot as being equivalent to those passed at a physical general meeting, under certain conditions. Postal ballots offer a convenient and efficient method for shareholders to participate in decision-making, especially when attending physical meetings is impractical. Detailed breakdown of Section 110. 1. Mandatory postal ballot for certain items of business. Clause A of Section 110 mandates that companies must conduct certain items of business only by postal ballot. These items of business are those that the central government specifies through a notification. The government has the authority to decide which specific matters should be handled exclusively through postal ballots. This provision ensures that certain critical matters, which may require broader shareholder participation or transparency, are dealt with more formally, without the constraints of a physical meeting. The central government may specify which matters require postal ballots to ensure that decisions on sensitive or significant issues are made through a method that allows for a wider reach and greater shareholder involvement, even from remote locations. 2. Optional postal ballot for other matters. Clause B allows companies to use postal ballots for any other item of business, other than ordinary business, which generally includes routine matters such as approval of financial statements, appointment of directors, etc., and matters where directors or auditors have the right to be heard at a general meeting. This provision provides companies with flexibility in deciding which matters can be settled through postal ballots, enabling shareholders to vote on resolutions without needing to attend in person at a meeting. The postal ballot process for these matters must be conducted in a manner prescribed by the regulations or guidelines set by the central government. The government will outline the specific procedures for the use of postal ballots, ensuring consistency, transparency, and fairness in the process. 3. Provision for electronic voting. Proviso to Clause B states that an item of business that is required to be transacted by postal ballot under Clause A may be transacted at a general meeting if the company is required to provide the facility for electronic voting under Section 108 of the Companies Act. This means that for companies that offer electronic voting, or e-voting, it is permissible for shareholders to vote on the relevant resolution at the meeting using electronic means rather than by postal ballot. This provision helps align the postal ballot process with modern electronic methods of voting, which enhance shareholder participation by enabling them to vote remotely. 4. Resolution passed by postal ballot. Subsection 2 clarifies that when a resolution is passed through postal ballot and has the approval of the requisite majority of shareholders, as defined by the company's governing documents or relevant regulations, the resolution will be deemed to have been passed at a general meeting. This ensures that decisions made through postal ballots are legally recognized as if they had been decided at a physical meeting, providing clarity and consistency in the decision-making process. The passing of a resolution via postal ballot can be considered equivalent to the approval at a general meeting, eliminating the need for a physical gathering of shareholders for the decision to be validated. This is particularly useful for companies with a large number of shareholders or those that operate in different geographic locations. For more details, contact us.